Good afternoon, everyone. We want to thank you for joining us today for our fourth webinar of 2019, Facing Down the Most Damaging Risk to Your Plan's Reputation. Today, we will examine the various operational risks of defined contribution plans in detail and share suggestions for developing a framework to help manage those risks. My name is Rachel Dickinson, and I will be your moderator today. I am the Deputy Director of Gwinnett County Human Resources, responsible for plan administration of our defined benefit and our defined contribution plan. Our panel today is Julian Reagan, who is the Public Sector Market Leader and a Senior Vice President in Segal Marco Advisors Boston office. Prior to joining the firm, he served as Executive Director for the New York State Deferred Compensation Board, Assistant General Manager and Budget Director for the Massachusetts Bay Transportation Authority, Vice President, Risk Governance and Strategy for Fidelity Investments, and as a state and local government appointee to the IRS Advisory Committee on Tax-Exempt and Government Entities. We also have Michael Hadley, a partner at the law firm of Davis & Harmon LLP in Washington, D.C., where he practices in the area of employee benefits, with a particular interest in 403B and 457B plans. Mike is a frequent speaker and author on the benefits and tax developments coming out of Washington. He provides public policy assistance to trade associations and financial institutions and serves as outside government relations counsel to the Spark Institute. He serves on Davis & Harmon's management committee and in 2018 was appointed the firm's managing partner. And lastly, we have Leah Feliciano. She is a Vice President of Retirement Operation Plan Management and Services at Voya. Leah oversees daily plan administrations for Voya's retirement customers, as well as several groups that support clients such as ERISA testing services, operational compliance and controls, and business support services. She is also responsible for large client implementations and has over 23 years of financial services industry experience. Before we get started with the presentation, we want to go over a few housekeeping items. First, please remain muted throughout the webinar so the presentation is not interrupted. We have designated time at the end of the presentation for a question and answer period. Throughout the webinar, you may submit questions at any time through the Q&A feature. Your questions will only be visible to the presenters, and we will answer as many of them as we can. If your question is for a particular panelist, please indicate so in your question. We are recording this presentation and will post it along with the slides to the NAGDCA website under Webinar Archives for you and any other members that may not have been able to attend. With that being said, we'll begin today's webinar. Julian will kick us off by going over DC Plan Governance and Risk Oversight.
Okay. Thanks so much, Rachel. I'm going to start at a spot that is a good launching spot for talking about operational risk for defined contribution plans, and that's by taking a look at the governance structure and oversight roles for a defined contribution plan. Now, on the lower right-hand side, the organizational chart is admittedly probably more suited towards a large plan with internal staff, but it provides the opportunity to make a couple of good points about managing risk that apply to plans of all sizes. The first is that in a defined contribution environment in the public sector, where the plan is delegating so many tasks to external parties and advisors, participant record keeping, for example, transaction processing to the record keeper, among others, security selection delegated to the investment manager, and surveillance of controls to the auditor. It goes to follow that the board or the board equivalent and the executive director or the executive director equivalent are delegating large amounts of responsibility for managing day-to-day risks to their service providers, certainly the record keeper, and advisors. The second point, though, is that regardless of the large amount of delegation, the board and the executive director or plan manager, whatever title you want to use, retains responsibility, of course, for oversight of the plan's overall risk management framework, its effectiveness, And of course, having served as an executive director myself, other folks who've been or are plan administrators or managers may also agree that even though it's not in your job description, the executive director or administrator typically has embedded in their role the board's expectation that you're going to help to manage the plan's reputational risk. In other words, you're going to be the board's eyes and ears, surveilling risk across the defined contribution plan environment. So if we go to the next slide and take a look on the next slide at the big ticket categories of risks that defined contribution plans are exposed to, historically, market risk has been the risk category that's covered by the media the most. And that's for pretty good reason. If you think about it, in 2008, the stock market lost 37%. Reportedly, target date funds across client groups lost $2.2 trillion. That was a pretty staggering event and well worthy of attention. That being said, if you think about it, operational risk, and you can see the definition at the top of the page, which is really a risk that's the risk of loss due to people, process, or systems failures or from external events, you can make the case that this category of risk is the broadest and the fastest growing risk exposure for defined contribution plans. If you think about it, defined contribution plans are more reliant than ever on technology. The financial markets are more complex. And of course, as we've seen with fee litigation, the threat of litigation, which is a type of operational risk, is also, if not growing, ever present. If you look on the right-hand side of this slide, you can see that operational risk encompasses many risk types. I'm just going to focus on several to make a few key points: legal and compliance, transaction processing risk, and data security risk. But another key point to be made here, and I think we all know this from common sense, probably from perhaps from personal experience, professional experience, I should say, when you think about operational risk events and compliance failures, as the study from The Economist reports at the bottom of this page, these types of failures really are the single biggest cause of damage to a service organization's reputation. And if you think about it, a defined contribution plan in the public sector really is a service organization. And it's really that strong reputation that helps you to encourage employees to enroll in the plan, encourage participants to maximize contributions to the level that makes sense for them, and hopefully encourages participants when they sever from service to stay in the plan and even potentially, hopefully, roll assets in from other tax-deferred vehicles if the plan document allows for it. So going to the next slide, I wanted to cite a few financial services industry examples to make the case that the link between operational risk failures and reputation risk is a very strong one. If we look at some of the biggest ticket risk events in the financial services industry broadly now, over the last decade and a half or 2 decades, we head back in the 2004 to 2006 timeframe, looking at the left-hand side here, the mutual fund trading scandals. And as many of you, perhaps all of you, will remember, these scandals involved allegations that some of the nation's largest, most reputable mutual fund firms allowed a subset of investors to enter trades after a 4 p.m. deadline, but get the day's pricing, the NAV for that mutual fund that day, in contravention of rules. The allegations also included allegations that certain mutual fund firms allowed a subset of investors or groups of investors to engage in market timing, rapid-fire trading in the funds at the expense of long-term investors, once again, in contravention of the written prospectus rules. So these events map right back to the 2 risk types that we just looked at on the prior page: transaction processing failures and compliance events. And of course, we know what the consequences were. The firms that were implicated were on the receiving end of hundreds of millions of dollars of fines from states' attorneys general and from other state securities regulators and from the SEC. And of course, many of these firms lost billions of dollars of assets. At least one of the firm's brand name is no longer with us to this day. Now, I know that Michael and Leah are going to be speaking to participant data issues and cybersecurity data breaches, DC fee litigation. I'm not so sure who's going to speak to it, but these other 3 categories of risk events in the financial services industry, fee litigation and loss participant data, are definitely defined contribution type risk events that have come with a heavy cost, as well as, of course, reputational challenges. Now, if we go to the next slide, we can take a look at the link between operational failures and more local defined contribution plan events. And I'm just going to take one, for example, in the interest of time. If we look at the top of this page, one operational risk event that we need to mitigate against, of course, is the potential for a compliance failure. You can have a record keeper in a Section 457 plan environment who continues to process contributions for a group of participants over and above the statutory limit. Now, this slide's a couple of years dated, but nevertheless, going over the 2019 limit. And we all know that a consequence of this type of failure would be, in the worst case, the plan losing its tax-deferred status. More often, when you have a breach of this type, the plan is going to have to enter into a cumbersome and costly correction process with the IRS, reconciliation process, and some unpleasant communications, necessary communications, but unpleasant communications to participants. Again, other types of failures that can occur are around transaction processing, financial reporting, record keeping, vendor selection, and again, data security breaches or errors that can occur when transmissions of participant data between employers and the record keeper don't have the proper controls in place. So the next slide is the good news. And the good news is, if we go to the next slide, that no matter what size your plan is, no matter where you fall on the continuum, no matter what category of plan you are, if you can visualize that first slide that we reviewed, all plans have in place a risk management framework with roles and responsibilities divided between the board, staff, the contracted service providers, and advisors. And of course, in today's risk environment, where the environment is increasingly complex, the name of the game is to continuously improve upon that risk management framework that's aimed at reducing the probability and severity of losses from risk events, and really in line with a concept that many of you may have heard of that's gained some traction in the wake of the financial system crisis called enterprise risk management. Enterprise risk management, or ERM, is a concept, at the risk of oversimplifying, that's aimed at eliminating the silos that have historically existed between groups in managing different types and categories of risks. So you get to a more effective risk management framework. Again, visualize that organizational structure that we touched on earlier on. Breaking down the silos between groups is what ERM is after. And if you think about it, a risk management framework includes four key components, all of which are going to be familiar to folks on the phone. You've got your governance mechanisms, your policies and your contracts. A great example would be your contract with your record keeper that sets thresholds for acceptable levels of risk around transaction processing. 0 failures is probably the case in most cases. Average speed of answer on the phone, on the telephone customer service line, website availability. And then a second component, and I'm not going to speak to all four components in the interest of time, but are your assessments. Your financial audit is surveilling the integrity of your financial controls. Your internal control audit, or an audit that may be performed by a consultant, your investment consultant, will look at transactions from the record keeper and compare them to the threshold set in the contract. And then finally, your investment consultant will be performing assessments around fees and costs, benchmarking exercises, also vendor reviews, and even participant surveys are a form of risk assessment. You take these together with measures and reporting, you've got an integrated framework. And again, the name of the game is to build on it, improve the documentation for it, make it more effective, to strengthen the fund, and put the plan in a position to continue to deliver high quality, cost-effective services in a risk environment that's changing. So with that, I'm going to hand it over to you, Michael, and look forward to listening to both you, Michael, both you and Leah.
Thanks, Julian. So it's my job here in the next 15 minutes to explain all the legal duties that impact your risks in operational management. And I'm going to do the best I can, but obviously I can't get to everything. If we start on the next slide, as a high-level framework, because we're talking to 457 plan sponsors, it's important to understand kind of what is the legal framework for your duties. And it's often said that, well, we're not really subject to ERISA, so we sort of follow them and we don't. But when you actually think about the duties that apply to a governmental 457 plan, they line up a lot more than you'd think. The basic duty under the rules for pension plans, for private pension plans, is a fiduciary duty of prudence, which, believe it or not, I'm about to do from memory. You have to act with the care, skill, prudence, and diligence under the circumstances then prevailing that a prudent man acting in a like capacity and familiar with such matters would use in the conduct of an enterprise of a like character with like aims. I just did that from memory. I say that because that's a lot of legal words. That essentially says, think about what a careful person that is knowledgeable would do in a similar circumstance. And that's basically what you do whether you're managing a private plan or public plan. Governmental 457 often have a mini ERISA type rule that applies to them. If not, as a best practice, they follow it. ERISA also requires that you follow the plan documents, and guess what? The rules that apply to 457 plans say the same. You want to make sure that the operation of the plan matches the plan document. ERISA plans generally have a fiduciary committee that has to oversee it, and as Julian just described, even if it's not called a fiduciary committee, there's often a group, one or more public employees that are responsible to oversee the plan. And then finally, an ERISA plan has to have an audit, and while governmental plans do not need to file a Form 5500, they do have to meet government accounting rules, and as you've probably heard, GASB rules are being proposed that would essentially treat 457 plans in many circumstances like pension plans. There's an important risk here that I didn't add, an important similarity, and that picks up on something Julian talked about, and that is reputational risk. One of the things that governmental entities have to face, even more than private entities, is everything they do is in the sunshine. And so when you have an operational error, not only do you want to get it corrected to keep the plan compliant, but you want to avoid something in the local newspaper. And you face that much more than somebody who's managing a private plan. If we go to the next slide, as you're thinking about your fiduciary obligations or whatever your local rules provide for you, you have to remember that when you're dealing with your plan, you're often wearing two hats. Sometimes you're acting as an employer, thinking about plan design, what can we change to make it better, making decisions about the basics of how the plan's going to work. And then maybe in the next sentence, you might switch to a different hat, and that is managing the plan operationally. You're going to be going back and forth quite a bit. That's an important concept to kind of keep in your mind. When you're dealing with the operation of the plan, which is most of what you do, you're wearing a fiduciary or some sort of similar hat. And so if we go to the next slide, let's sort of start thinking about what does that mean? I mean, what does it mean to act prudently? What does it mean to have skill? What does it mean to act as a prudent expert would in similar circumstances? Well, starts with governance. And there's a lot of overlap with what Julian talked about because the folks that actually help implement these things are following kind of best practices for legal oversight. You want to think about, importantly, identifying who actually has authority. Right? Where in those boxes that Julian showed you are the decision makers, and who are the people that are overseeing the decision makers? Important to understand, not only have we designated the right people, but do we have a system to deal with changes? When somebody retires, is the next person in their position automatically in charge of being on the committee or in charge of oversight? Or do we have to nominate somebody, and if so, how do we do that? That's just as important as having something like a committee with governance and regular meetings. We talk about periodic training of fiduciaries, of course, and that's done in a lot of ways. It is not simply having somebody like me come in and occasionally talk about fiduciary duties. It's sitting in webinars like this. It's making sure that people that have institutional knowledge are training each other. Boy, a lot of what goes on to make sure that the right things are being done are simply making sure that people understand institutional knowledge, because a lot of the issues that come up from an operational standpoint have probably come up before, maybe with that plan or with another plan that somebody's dealt with. And not only that, you want to make sure that you're documenting pretty much every decision that you're making. But this is a long-standing thing that lawyers have been saying for a long time. We actually like documentation. Importantly, documentation that whoever's in charge thought about the issue and made a decision based on the facts that were collected that were relevant. Because very often, I actually don't care what decision my clients make. What I care about is that they thought about what facts they need to collect. To the extent they didn't have the expertise, they brought in an expert to help them, and they documented that they discussed it and made a decision. Lastly, to kind of pick up what I said earlier about reputation, the number one most important thing to do to make sure that you're meeting your legal duties is to deal with mistakes honestly. Because governmental plans are not under the same level of scrutiny from the IRS as private plans, and certainly not under the scrutiny of the Department of Labor like private plans are. There's sometimes a tendency to say, gee, I really don't want to deal with that. And that only compounds the error. I think most professionals understand that. If you're important enough to be listening to this webinar, you're important enough to have been put in charge. And I think you understand that, but it's worth repeating. If we go to the next slide, we talk about sort of the way that you work your operational oversight, right? And as Julian sort of mentioned, most of the work that's done to operationalize the plan is actually done by service providers. I mean, most of you all are not processing transactions, you're not taking calls, you're not dealing with distributions, you're not dealing with loans. So you hand that over to somebody else, and the most important way in which you oversee your service provider is the contract. That contracting process is absolutely critical. One thing that makes 457 plans a little bit different than private plans is not only do you have to deal with directly with the contract, but there's often a larger structure within your organization that oversees contracting with vendors. And it's really important that while you have to meet your own government contracting requirements, that you tailor the contract to the needs of your plan. And that is not the same as, for example, getting a vendor to do the computer system for the city manager. As you're working through your contract with your service providers, you want to make sure you're properly allocating who's liable for what, and importantly, what happens when something goes wrong. Are you sure that your service provider is not only going to make it good, but to make sure that they will perform the correction, and if there's anything due to the plan because of the error, if it's their fault, that they're taking care of it. As Julian noted, it's important to have measurable metrics. On my next slide, I'll provide some examples. And then finally, one of the things we say to 457 plans is that it's important to make sure that you have review of your contract by somebody who understands plans. It may not be enough to have the local city council, who is a generalist by nature, that it is worth, if you can afford it, to have somebody who's familiar with 457 or plans generally review these contracts. That's important because they will make sure that they have metrics, that they have the proper liability, they capture the things that you want to have captured. If we go to the next slide, I'll just quickly show sort of the common provider metrics that we see in contracts. That is to say, these are the things the contract will often build in to say, hey, you service provider, need to make sure you meet this. And if you don't meet it, there are measurable penalties that will be applied, and perhaps reduced fees or something else. Some of these things you want 100%, right? You want 100% investment transaction processing accuracy, and you want them to be on the hook if they don't get 100%. Other ones you don't necessarily need 100%, but you want to have something that's measurable, and just as important, not only to have measurable metrics, but to have periodic reporting, so that you're actually hearing from them on a regular basis, did we meet these metrics? And if so, and if not, why not? The last couple slides that I want to talk about before I hand things over. On the next slide, we talk about common compliance errors, and why is that important from the standpoint of kind of legal oversight, right? So at the beginning, I recited from scratch the Prudence standard, which is a bunch of legal words that essentially means you should act with a level of care, a level of prudence that somebody expert in these matters would act with. And one of the things we know about operation, it really doesn't matter what the endeavor is. When you're either dealing with operations or with audit, you concentrate on the areas where things tend to go wrong. And you take the experience that you've had and the experience of others and you focus there. I mean, there are lots of parts of your plan document that describe rules that you have to follow, but they're just not likely to go wrong, right? But there are some things that tend to go wrong over and over again, often caught by a service provider, caught by you as the plan sponsor, or caught by the IRS on audit. And of course, here's the list. I won't read all of them. Many of you are familiar with them quite a bit. 457, some particular ones that can go wrong are the special catch-up contribution that's available, as well as the requirement to make a contribution election in the month prior to the month that it begins. 457 plans also have a different rule for hardship distributions called unforeseeable emergency withdrawals that unfortunately the IRS has given us very few rules about. So it's important that you build rules into your plan and make sure that they're being followed consistently. And then the only other one I'm going to mention is the first one on the list. If you allow loans in your plan, that is a very, very common area of noncompliance. Even the best service providers have problems with them. Even the best plan sponsors have problems with them. It's important to keep track of that and make sure they're being done properly. I'll end by just giving you a sort of a sense of some of the emerging issues that we see in plan administration, which is on the next slide. So most of the stuff I've talked about, I think I would have given the same presentation the last 10 years, because the legal framework for fiduciaries and those overseeing plans largely hasn't changed. In fact, it builds on some of the oldest principles in the law, the notion of what a trustee is supposed to do when they're in charge of a trust. But one of the things that I said in my long recitation from memory was that a fiduciary must consider the circumstances then prevailing, which just means you have to ask yourself, gee, what's going on right now? The issues that we thought mattered in 1974 when ERISA first created kind of this structure for oversight of plans, the issues that we thought were important when many of your state and local statutes were first put in place just are not the same ones that exist right now. It's important to keep track of emerging issues because that's the area where you're most likely to have risk. Julian gave a four that are recent examples that we wouldn't have worried about 20, 30 years ago. And here are some of the emerging issues. Number one, making sure you're keeping track of where your participants are. There have been a lot of examples of regulators cracking down on plans for failing to kind of keep track of their participants when they terminate employment, because you either want to make sure you get the assets to them at the point they leave so they don't go lost on you, or make sure that you keep a good address and you stay in contact with them as best you can. One way to try to deal with that is if you've got a small account cash out provision, make sure you're following it and you're getting the assets into an IRA for those small accounts if the participant doesn't elect otherwise. So working with an automatic IRA rollover provider. I don't have to say that cybersecurity is an issue. If you don't know that, you've been living under a rock. I mean, I think most executives say the number one thing that keeps them up at night is a cyber breach. And it's true with a plan just like it is with any other financial instrument. And that is an area where you can certainly concentrate on your service provider, make sure they can give you good answers to their cybersecurity. That doesn't mean you need to test everything they do. In fact, they probably don't want you to understand all of the measures they have in place, because part of cybersecurity is keeping your security secret. But there are a series of mechanisms that they can do to provide you with audits, to provide you with answers to questions, and that is an area where you certainly need to probe quite a bit. We're also seeing increasing interest in automatic enrollment. Apologies, it looks like our presentation just went off.
Yes, sorry everyone, it disconnected on me. Give me just a minute here and we'll get it pulled back up. And Michael, you can just keep on talking. Okay,
sure. So on this slide, one of the areas that's emerging is automatic enrollment in 457. 10 years ago, no 457 plan had an automatic enrollment feature. That is to say, a feature where when somebody starts employment, they're enrolled in the plan unless they opt out. That's now sort of common in 401k plans. It's increasingly coming to 457 plans as more recognition that it would be great to get folks at least saving a little bit. Now, for many of you all, your statute will not support that. And by the way, there's great information on NAGDCA's website about different states and whether they allow auto enrollment or not. If you've not checked out the map that's on the website, I'd say that's the first thing you should do after you finish our webinar, because it's really useful. Anyway, when you add automatic enrollment, one of the issues that you will often have is operational errors. That is actually really hard to do well. The payroll system has to be working properly. You got to watch for rehires, and it's not something that you can just add without thinking through. It's a great feature, but make sure operationally you're ready for it before you add it. That's particularly an issue where there's a lot of payroll systems spread throughout the system. So, for example, if you participate in the state 457, there's going to be dozens, possibly hundreds of payroll systems that have to integrate. Two other quick issues. One, as we're increasingly trying to help participants, trying to help our employees kind of manage their assets, more and more individuals are coming in to meet with your participants to provide them education or possibly advice. It's really been common in the 403B world for a long time, but it's increasingly arriving to 457Bs, and that's important to understand what they're saying and why they're saying it. And then lastly, I would just point out we're seeing an increased interest in making it easier to communicate with participants electronically. The Department of Labor just put out a proposal about a month ago that would allow ERISA governed plans a new way to communicate electronically with participants, and as a best practice, this easily could come to governmental plans. So it's worth watching that as well. I think with that, maybe I will just hand things over so you can hear a little bit more about how to operationalize this in practice. Leah, it's all yours.
Great. Thanks, Michael. So you've heard about a broad gamut of risks that sponsors face in their role as a fiduciary, and record keepers share these risks and recognize it's critical to have the right systems and processes in place for the benefit of our customers as well as the success of our business. Listed below, there are 4 areas related to operational risks and controls that I wanted to touch on further, as well as some best practices that can be considered to help with mitigating these risks. The first item is plan compliance. So Julian and Michael both mentioned that failing to operate the plan in compliance with plan and IRC rules can have significant consequences, including financial, reputational, and plan qualification risks. This starts with when the plan is set up and continues as changes occur. Validating the plan is set up in accordance with the plan rules and automating functionality wherever possible are important steps that you can take to avoid issues with manual processing and interpretation of plan features. Record keepers should be able to demonstrate through documentation and test environments that plan compliance remains intact. This can also be periodically reviewed through annual plan audits of functionality, as well as optional independent audits to look at sample sizes for plan compliance. But one other area in particular that can lead to issues was mentioned previously, which is related to unique plan features that cause manual processing or custom programming to administer. Michael mentioned a few examples such as complex vesting schedules and certain distribution options. And sponsors, consultants, and record keepers equally need to pay special attention to these features to ensure understanding of the processes, setup, and controls for these transactions. Next, having a robust test environment is another way to help validate the plan setup and future changes are in compliance with all required rules, as well as ensure there are no surprises once the plan or the new feature goes live for your participants. This can allow for end-to-end testing of functionality, as well as offering the plan sponsor a level of confidence about how the plan is being administered. But beyond ensuring the plan is set up correctly, it's also critical to consider how and what data is received in the record-keeping system. I imagine it wouldn't surprise most on the call to hear that data is a key aspect of accurately administering the plan. And ensuring data is received or mapped in a way that's in sync with how the system was programmed can help avoid some of the issues mentioned. Utilizing data conversion tools can help avoid errors with data mapping and handling varying layouts and data fields from other providers. This can also help minimize blackout periods if you're making a provider change to avoid unnecessary time where participants can't transact on their account. The next item is mitigating fraudulent activity. You can see by the information on this page that account takeover fraud continues to grow, and the statistics are staggering. Billions of records have been stolen through data breaches in recent years. Identity theft continues to trend upward. From 2016 to 2017, losses from account takeovers rose 122%, and in 2018, it increased by 164%. The cost of these attacks tripled from 2016 to 2017, reaching an estimated $6.5 to $7 billion. And according to Juniper Research, losses from fraudulent online transactions are expected to reach $25.6 billion by 2020. Criminals are organized and specialized. On the next slide, so what do we do to combat this? As a record keeper, there is no single silver bullet. You need to have a variety of security measures to safeguard the confidentiality, integrity, and availability of client data. But it's also important to recognize that safeguarding clients' data is a shared responsibility, and some aspects of prevention require the cooperation of sponsors and participants to utilize best practices that can mitigate a participant's risk of account takeover. I'll talk about e-delivery and registering your device on the next slide, but another way to mitigate this risk is through use of multi-factor authentication for access to customer accounts. This typically consists of using a username, password, and device registration, and new processes have been developed by many providers to issue one-time passcodes for additional controls. And of course, it is also important to have secure transmission methods for any exchange of participant data, whether that's through secure file transmission or utilizing a protected website that your provider may offer. How can participants contribute to protecting their account? Consider this. If someone does not register their account, they can risk takeover threat. If someone does not get statements mailed to them, they can reduce mail fraud threat. If a participant opts in to electronic delivery, then they can get notifications in real time, not waiting for mail, for any possible transactions that they did not make. Password changes, ACH banking changes, things of the like. Also, participants who actively engage with their account through digital channels can stay on top of their account balance and activity more frequently than relying on periodic statements or confirms. This is why registering your secure device is such an important step for participants to take to protect their accounts. If someone tries to log in from an unregistered device, it can initiate an email or text passcode to the participant to authenticate the account and prompt them to register their device. We know it can be difficult to engage participants in retirement planning, and encouraging them to take this important security step can also help try to drive interaction with their account and the retirement planning tools offered by the plan. Another area mentioned earlier as a continued evolving trend is data security. You see some of the top recent data breaches listed, and I'd be willing to bet most, if not all on this call, have stayed at a Marriott at some point in the past, which means you can assume your information has been compromised. At Voya alone, we're subject to, on average, almost 24 million threats a month, and we are not unique in that regard, which is why it also makes it so important to have a proactive approach that encompasses people, process, and technology. If you're not proactive about evolving your security measures daily to match and anticipate the threat landscape, then it's simply too late. Hackers find new ways to compromise security every day, and we know it isn't just about technology. The bad guys are always searching for the weakest link, and that is usually with people and process. You don't need to look further than the Anthem attack in 2015 to see how devastating that can be. So it starts with having a highly skilled and trained security workforce that focuses on combating threats every day. Companies hire certified information security professionals who in many cases have military and government backgrounds. It's also become quite common for firms to hire certified ethical hackers. These groups can participate in global capture the flag or hacker competitions, which gives them a chance to test their skills and learn new techniques that can be brought back to improve internal defenses. But I also really want to emphasize how important it is that every person across the company is also trained and vigilant about protecting participant data. Phishing attacks are the #1 attack technique to gain or compromise security. We experience almost 860,000 attempts a month, which is why it's so important to conduct routine tests and training for employees against these attempts. We conduct roughly 85,000 tests annually that go all the way to the level of our board of directors, the CEO, and executive management. And these tests and training can drive down phishing susceptibility significantly. After people, having industry best practice policies and controls are the next aspect to maintaining data security. It's important to ensure that your policies and controls are appropriately designed and tested for effectiveness. To understand a firm's processes, you can review their SOC 1 and SOC 2 certifications. And as a reminder, the SOC 1 certifies that operational controls over financial reporting are effective, and the SOC 2 certifies that controls over the security of client data are effective. In addition, you can ask your partners if their IT policies, standards, and procedures align with best practices, the International Standards Organization, ISO, and National Institute of Standards and Technology, known as NIST, which are security frameworks that set best practice standards. We've also found that there are benefits to actively collaborating with industry and government intelligence services to stay informed of security risks. The Financial Services Information and Sharing Community, FS-ISAC, is a government-sponsored organization in the private sector that allows companies to stay informed of non-public international and domestic security risks. And this also results in partnerships with our peer groups within FS-ISAC to assist the FBI in investigations against bad actors. Providers can also enter into an agreement with the Department of Homeland Security that allows them to gain direct information on alerts on domestic and international threats, so we can incorporate that information into our security protocols and take protective measures. One example was the WannaCry ransomware attack in 2017, where we were notified and able to quickly install a patch to avoid that threat. And we've also found that it's important to monitor the dark web or internet underground marketplace for any information that could have a potential impact. When it comes to technology, you need to have systems that are designed to prevent corruption and unauthorized access. And while having firewalls and antivirus software are probably considered standard defense methods, it's important to have various layers of security controls that work in unison to provide maximum protection. These layers serve as barriers between an attacker and business-critical information resources. And by having multiple security layers, it enables you to establish an in-depth defense architecture that's designed to prevent unauthorized access to information through a broad range of items, including authentication, access management, monitoring and response, and data encryption. Record keepers can also use data and behavior-based predictive analytics to detect potential fraudulent activity on customer accounts and flag them for investigation. As mentioned earlier, fraudster activity has been on the rise across the industry, and therefore it's critical that we train our frontline and customer-facing employees who are handling transaction requests on the latest fraud techniques so they can detect and prevent potential incidents. And this goes above and beyond phishing. Some examples of technology include validating if calls are coming from authenticated numbers they've dialed in from before, having a customer profile model where typical interactions and account activity are considered, using a geolocation model, checking to see if the activity seems consistent with address or location information for the participant, as well as using a bank model that evaluates ACH changes for reasonability. Providers can then use this information to evaluate the level of risk and determine if action needs to be taken on an account. In today's on-demand economy, participants expect high system availability, especially when markets are turbulent, to be able to transact or obtain the information they want when they want it. Having a comprehensive business resilience plan with a detailed playbook is key to limiting disruption. And a couple of components that are necessary include data centers, disaster recovery, and business continuity plans. For data centers, maintaining multiple top-tier centers are at the core of ensuring high availability, redundancy, and resiliency during unexpected events or threats that can impact an organization's ability to service their customers. And having data centers that are located in different geographic regions can also help ensure that the redundant sites aren't susceptible to the same events. You should have disaster recovery plans that are defined, tested, maintained, and monitored. Disaster recovery plans should have defined plan owners who are accountable for the recovery readiness of every application. And these plans need routine exercises to ensure they can be recovered within the defined time and point objectives. Some of the types of tests that should be reviewed routinely include a level 1 plan review, level 2 walkthrough or tabletop exercises, and level 3 simulation or test of plan procedures. And lastly, business continuity plans are required to address actions to be taken before, during, and after an incident or disaster. Risk assessments are leveraged to identify potential gaps with risk of occurrence in order to determine your recovery tolerance for core processes. And your exercise and maintenance strategy consists of incremental exercises above what was listed for the disaster recovery plans, including leveraging automated notification systems. The last area I'll focus on is related to the use of technology and digital tools. As industry and technology changes occur, there's been a shift in objectives and goals across constituents, including record keepers, sponsors, and participants. For record keepers, we've moved beyond a narrow retirement focus to having a broader view of participant needs. As a sponsor, while cost efficiency continues to be a high priority, having a focus on driving results and broader financial wellness are equally important. And for participants, while their core need is still a paycheck in retirement, although that burden often falls more on them through defined contribution plans, they also need personalization and consideration of non-retirement goals to help them understand the steps they need to take to achieve retirement security. As the use of digital and mobile technology continues to increase, the question to ask yourself is, do technology enhancements or lack of impact participant outcomes? And while ERISA went into effect decades before the digital age, the legislation contained a crucial provision, which is that fiduciaries must act with diligence under the circumstances prevailing. In the 21st century, employees are making important financial decisions on digital devices, including those that affect their retirement. And to quote my fellow panelist, Michael Hadley, accordingly, even though no fiduciary in 1974 would have needed to consider the digital design of the plan's web portal, the fact that a substantial percentage of participant interactions are online is a circumstance that is now prevailing. Research has shown that the design of digital screens, including how the choices and information are presented, can dramatically impact the way workers make decisions and save. So given the potential influence of digital design on retirement choices, providers have a responsibility to build websites and apps that encourage better decision-making, and sponsors should consider bringing the same oversight and diligence to digital platforms that is currently brought to plan design. For these reasons, you should consider an additional fiduciary obligation, the digital fiduciary. If you're a plan sponsor, advisor, or consultant, there are steps you can take to understand how companies you work with integrate customer feedback and driving positive outcomes into their technology enhancements. Listed on this slide are a few items you may want to consider incorporating into your governance process, such as the digital policy statement. On the last slide, so to close out, you've heard about a wide range of risks that need to be considered that can create a high degree of financial, data security, and reputational risks. Providers can consider some of the best practices outlined, and sponsors and consultants should have a discussion with their provider or a provider they're considering to ensure they have an understanding of their policies and technology related to these risks. Below, we've also included a sample list of questions you can use to begin those discussions. And with that, I'll turn it back to Rachel.
Thank you, Leah, and thank you to Julian and Michael. As you can see, there are many operational risks to keep in mind as plan sponsors. Our panel did a great job of explaining the complexity of those risks and highlighting the various ways plan sponsors can provide adequate oversight. Creating a framework for managing operational risk is key to reducing costs, improving compliance, and protecting the tax-qualified status of your plan. So now that our presentation portion has concluded, we'll move into the Q&A segment of the webinar. And we have a few questions, and either panelist who feels most equipped to answer this, please feel free to chime in. So the first question is, does a plan with more than one provider have more risk, and can a plan with more than one provider operate the plan documents from provider A and the plan documents from provider B? So if they have more than one plan provider, can they use the plan documents of both plan providers?
I'll tell you what, this is Mike. I'll take the second half, and then I'll let the experts actually in risk answer the first half. The second half is, can you have multiple plan documents? Yes, you can. And that's not uncommon in the 457 space. It's certainly very common in the 403B space. It's not ideal, obviously, because the plan documents describe the rules that apply to the plan, and all else equal, you would like to have similar rules apply. While many things are kind of the same in every plan, they're not all the same. It's important, obviously, that if you have multiple vendors, that they coordinate to make sure that you're not going over limits and the like. As to the risks with having multiple vendors, I I think the other speakers are more capable of kind of providing their experience in that area.
You want me to take a shot? Or, this is Julian speaking. I'll just take a brief shot at, I'm going to give the dreaded qualified answer to the first question. So on the one hand, if you have more than one provider, you've got more interfaces, you've got more risk. That's what a risk management professional would tell you. On the other hand, you're diversifying your institutional risk because you have two providers, so it's possible that you get a benefit from having two providers. So in conclusion, the answer is it really depends. But all things being equal, if to use an exaggerated example, if I'm running a defined contribution plan and I have 50 interfaces and I can consolidate those interfaces to 25 interfaces, all things being equal, I've reduced the probability of failure.
Okay, thank you. And I encourage you all, if you have any other questions, please go ahead and ask now while the Q&A feature is still live. We do have another question, which is what is the cyber risk associated with record keepers who outsource some or all functionality to third parties that are overseas?
And this is Leah. I think I can start on it, and then I don't know if others have something that they want to add in. I think, the first question is to really understand any providers that you're working with, what functions they have overseas, right? Because, in many cases, especially in the government market, there is a limit to the type of offshore work that occurs. But in the instance where there is work being performed overseas, I think it's important to understand what type of work that is, what type of data interactions occur overseas. Is it access to data versus storage of data overseas? And then I think it's important just to have a strong framework in place for vendor risk assessments, establishing security protocols where I would expect that they should be subject to the same rigorous security protocols that you have in any on-site presence. And then in many cases, I think that you'd find that a lot of them have more rigorous processes in place. But a provider certainly should be able to give you a full sense of what work is being done overseas, the nature of that work and the detail of that work, and then what their vendor risk and security processes are to manage and oversee that.
So, Michael, did you want to go? I was going to give one quick comment, but
Go for it.
Yeah, well, first of all, I'm not going to answer the question as expertly as Leah just did, which was a terrific answer. But what I'd really be interested in knowing is what's the statutory and regulatory framework like in the country where this work is domiciled, and what are the standards? If they're not good, it could be problematic. If they're at a level of our country, the United States, then that would be more acceptable. But I'd want to take a look at the statutory and regulatory framework in the country.
Okay. And then I think we have another question, which is, what is the risk if the provider of the state's 401A plan is the same provider of the county's 457B and 401A?
This is Mike. Maybe I'll start with this one. Every state has a different relationship between sort of its state plan and the sort of county, city, 457 and or 401A. If there's 50 states, there's 50 plus, lots of more than that relationships. So it's hard to generalize. It's hard to generalize that. Just like the question we started with, there are pros and cons of having a single provider that covers multiple plans. The advantage is that you're limiting the amount of due diligence. I would not, however, say that if you're the county, that you can simply rely on the state to kind of do your due diligence for you over that provider and their operational processes. Because, first of all, many providers have a different group of people that will service, say, the 457 market than are servicing the state's 401. Secondly, the types of issues that you might face in the state 401 plan could be very different than the types of issues that you might face in the 457. Just to take a simple example, the catch-up rules are different. And 457s will have employee elections and will tend to have more direct employee engagement than the state 401. Of course, it varies by state. All that said, there is something advantageous about having a provider that knows kind of both the state issues as well as the local issues, particularly if there's sort of an interaction between the two. For example, eligibility for one might make you eligible for the other, or might not make you eligible for the other. There's some advantage to be done there, as well as if there's provisions for transfer of assets among plans, voluntary or otherwise.
Thank you for that, Michael. And it looks like we don't have any other questions, but I think I have a question I would like to pose to the panel. For plan sponsors, how does one go about implementing such framework that we've referenced in this webinar, or monitoring the risk on an ongoing basis if they already have one established or they feel like they can improve upon the framework in place?
I could take a quick shot at that. Rachel, one way to do this is to improve upon the documentation you have in place. So Michael talked about the contract. Take a hard look at that contract with the record keeper. Make sure it's got the right thresholds around acceptable levels of risk. Take a look at your investment policy to make sure that it speaks to, in a right way, in a practical way, management of risk under the investment program. And if you really want to do it, and this is not the right solution for everybody, but you might say, you know what, we're going to draft a risk management policy. It's going to be broad. It's going to encompass all four components of that framework we just looked at, your other policies, your contracts, your measures, and your reporting. And we're going to use that as kind of an overlay. That's an approach on the one hand. On the other hand, that's not right for everybody. But I think the better organized your documentation is across those functions, the more programmatic you are about your assessments, the timing, the categories of assessments you conduct, you're going to be moving the ball forward on managing risk. So that's my 2 cents.
Thank you. And that wraps up our webinar today. I want to thank everybody for all of your questions and for taking the time to attend today. And as a last reminder, remember the presentation and the recording will be posted on the webinar on the NAGDA website under archived webinars. Thank you and have a good day.